The test for the mental capacity to make a will, known as testamentary capacity, is set out in the 1870 case of Banks and Goodfellow, in which the court said that it is essential that the testator shall understand the nature of his act and its effects, the extent of the property of which he is disposing, and shall be able to comprehend and appreciate the claims to which he ought to give effect, and, with a view to the latter object, that no disorder of mind shall poison his affections, pervert his sense of right or his will in disposing of his property, and bring about a disposal of it which, if his mind had been sound, would not have been made. That essentially boils down to 4 key points. First, did the testator understand what they were doing, i.e. making a will, and the effect of that? Secondly, did they know the nature and value of their estate, broadly speaking? Third, did they understand the consequences of including and excluding certain people under their will? For instance, if a person wants to write out a loved one from their will, they can do that, provided they understand and appreciate what they're doing, and are aware of any potential claims that may give rise to. And finally, were they suffering from any disorder of the mind which could have influenced their views, for instance, dementia or schizophrenia? All 4 parts of that test have to be met, and a failure of any one of those could render a will invalid. The law in this area, though, has evolved since that 1870 decision, given advances in medicine and science. As a case in point, in the 2010 case of Key and Key, this involved a husband who'd given instructions for a new will just a week after his wife of 65 years had passed away. Understandably, he was said to be absolutely devastated by the loss of his wife, and it was held that that devastation led to dementia-like symptoms at the time he made his will, which rendered his will invalid. There are often telltale signs that a person lacked capacity to make a will. For instance, the medical records often provide clues, as does the will-making file, and crucially, the evidence of anyone who knew the testator. More often than not, though, it's a combination of this and many other elements which together help to build a picture and establish whether or not a person had capacity to make a will.